It sounds like you're talking a lot from the federal aspect, but here in Tennessee, there's been a lot of talk about reforming or reinventing the way that the judiciary
Right.
system works. Have you looked at that at all? And
Yeah.
what are some of your thoughts?
I have, and actually the federal was a reflection of the states, because in the federal convention you had both Madison and Pinckney said, hey, we're just taking what the states did and we're doing it that way. So when you look at the original state constitutions, including the one from you guys, 1796, and you've been through several since then, you look at those original principles, that's where you want to get back to. So where you are now, for example, the Missouri plan, which is the next step, that takes judges further away from the people. And the further you move them away from the people, the more problems you're going to have, the less accountability you will always have. And so the founders were very insistent that you always keep judges moved toward the people, because they are the least accountable branch, especially when you go through retention elections. And that's another thing that the founders were really opposed to at the state level, is retention elections. They wanted straight out elections of judges, and that way they're accountable for the decisions of what they do. Particularly what's happened with the federal courts is back in the late 1890s, they said juries don't need to have the power they had. We need to reduce juries. So now, even at the state level in Tennessee, juries no longer have the power that they had under the original Constitution, under the revised Constitution. So that's even a check and balance taken out of the courtroom. Juries used to be a check and balance on the judges, not on the verdict or decision, but on the judges. And so now that's removed. So really, you're through several layers. You move from the elected judges to retention elections, now to the Missouri plan, and each one keeps getting further away from the people. And the more you do that, the more likely you are to have abuses, the more likely you are to have the same problem we saw in this room with Court of Judiciary hearings, unanimous voting down on it, because they're just not policing themselves, and they can't. It takes an outside body, not part of the judiciary. Typically, at least the founding philosophy is, you want the legislature to be the check on the judges, not the judges to be the check on the judges. So it's preferable to have something like a legislative committee actually be in the COJ, rather than the COJ, which is it's the foxes guard in the henhouse kind of stuff. It's their own guys, and you need an outside body.
Now, back to the retention election issue. You have people on here on Capitol Hill who say, well, voters elect us, and then if they elect the governor, if the governor is the one who's choosing these individuals, then there's some sort of level of accountability before it goes to retention. What's the flaw with that?
The same flaw as saying that bureaucrats are accountable to the people. They're not. The governor appoints bureaucrats. Do they answer the people? No. Anytime you move things away from the direct touch of the people, and you insulate it by going through the nominating committee that goes to the governor, and the governor puts them, now you're talking 3 or 4 levels. And so if you have an uprising out here with the people, you've got 3 or 4 levels to buffer it down, and by the time it gets them, it's just really not an issue. So that makes the same sense as saying that bureaucrats are accountable to the people because we elect the governor appoints the bureaucrats. No, it doesn't work that way.
Now, back to something you said earlier about the fox guarding the hen house and the judicial ethics commissions type thing. How does Tennessee fare in that compared to other states?
That's another kind of anomaly within Tennessee. It's kind of like the Attorney General being with Judiciary. You lose that separation, check and balance, and the same with the COJ, because it is. And it's kind of the same philosophy here when people say, now wait a minute, you got the federal courts, you always have courts of appeal, and they can check and balance the lower courts. And yeah, it sounds good, except the Supreme Court gets 8,500 appeals a year, and they only take 40. So are we saying that 99.6% of all cases are decided perfectly, and only the Supreme Court? It doesn't work that way. So you have to have an outside body, and the COJ is an inside body. And the fact that they have so little enforcement power, even when they write up a judge, they have no teeth to be able to go in and say, hey, here's your letter, reprimand, put it in your file, and then he just keeps doing what he's doing. So the lack of enforcement capability, the lack of incentive to have enforcement, because these guys work with the judges and part of it, it's just a difficult thing. And so that lack of separation of powers creates very few checks and balances.
Now, the most recent legislation to kind of rehab this new ethics board, it includes, the option of, judges, not only those who are sitting, but retired. Does that make that?
It's still the same vested interest. Thomas Jefferson had a great quote, and he called judges a corps, and they are. You have a loyalty, camaraderie. It's like being part of a fraternity or sorority. I mean, even after you graduate from school, you still have a loyalty to that group. And so having that loyalty to the group, and Jefferson says our judges are as honest as other people and not more so. They have the same power and privilege as others in their corps. And so when you have a group watching the group, they have a vested interest in it. Well, you know, I had to work with him. He's a good guy. I know he did this wrong. When you have an outside group that can step in and say, no, here's the plumb line. You've crossed the line. You can't do that. It's a whole different incentive. So literally under separation of powers, even the reform plan that's out there is still got too much judiciary watching judiciary. It needs to be under, actually, the way the federal constitution in most states do it. You have a legislative body that watches judiciary, and that's literally in Congress what we have, and that's why we have impeachment hearings and impeachment proceedings, and that's all done by Congress. It's not done by legislative. It's not done by judicial body. And the COJ kind of is acting like the Judiciary Committee would in the federal Congress, and that's just not a good separation of powers.
So for average Joe, who maybe doesn't find himself in court all that often, or maybe does, why is this important?
It's important because he may find himself in court. And if you find yourself in court, you want to know good and well that there is a body that can check and balance to bring justice, because the objective is justice. The objective is not having a system that works. The objective is achieving justice. And so you want every guarantee. I hope I never use the judicial system, but if I ever do, I want to know that it's going to be a just system, that every tool has been given me that I can have justice if I get there. I don't want somebody being able to railroad me and have nobody that can stop them or nobody that will stop them. And so that's why it matters, not because anybody knows anybody that's had this, although there are plenty of testimony on all the atrocities and abuses. But you may end up there someday, and it may be you, and at that point, you sure want the justice.